He had a valid permit, a registered firearm, 40 years of responsible gun ownership behind him. He had done nothing wrong, not a single law broken, and the officer searching his vehicle without a warrant over his clear and repeated objection was about to find something that would destroy the next 3 years of his life. Not because he was a criminal, because nobody had told him the rules had changed. The Supreme Court of the United States just issued a ruling that directly affects every single person who keeps a firearm in a vehicle. 9 justices, 0 dissents, the most unified decision on gun rights in a generation. And if you carry in your car, or you know someone who does, what you are about to hear could be the most important legal information you receive all year. I'm Sarah, 10 years in the firearms industry, and this is Gun Guide Pro. Let's get into it. Before we go any further, subscribe to Gun Guide Pro right now and turn on every single notification. We are a new channel and we are building something genuinely valuable here. Honest, plain language coverage of the legal developments that directly affect your rights as a gun owner. Every subscriber tells us this content matters. Every like gives us the motivation to keep going and bring you even better coverage. This takes 2 seconds and it costs you absolutely nothing. Hit that subscribe button. Hit that bell. And let's make sure you never miss a ruling that could protect your life. Now, let's talk about what the Supreme Court just said and what it actually means the next time you get pulled over. To fully understand why this ruling is so significant, you need to understand the problem it was built to solve. Because for years, quietly, on roads across every state in this country, 2 of your most fundamental constitutional rights were being pitted against each other in a way most gun owners never discovered until it was too late. The Second Amendment gives you the right to keep and bear arms. That right is foundational. Millions of Americans exercise it every single day, legally, responsibly, and without incident. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government agent can search your vehicle without either a warrant or a specific, legally defined justification called probable cause. 2 constitutional rights, both clear, both settled, both foundational. Here is the collision that was developing in lower courts across America. When an officer pulls you over and learns there is a firearm in your vehicle, what does that information legally authorize him to do next? Courts in multiple states were beginning to answer that question in a way that should alarm every gun owner in America. The reasoning went like this. Firearms are inherently dangerous. A firearm in a vehicle creates an inherently unsafe situation. Therefore, the officer has automatic search authority, regardless of whether any crime was committed, regardless of whether the gun is completely legal, regardless of whether the driver has done absolutely nothing wrong. Follow that logic to its conclusion. If the mere presence of a legal firearm gives law enforcement automatic search authority, then exercising your Second Amendment right simultaneously eliminates your Fourth Amendment right. You cannot have both. You are forced to choose between them. That is not what the Constitution says. That is not what any honest reading of the Constitution has ever meant. And it took a 9-0 Supreme Court ruling to stop it. Drop your answer in the comments right now. Have you ever felt like your Second Amendment rights and your Fourth Amendment rights were in conflict during a police encounter? Which state were you in? I read every single comment on this channel. Cases like this one do not start in marble courtrooms. They start exactly where yours would, on the side of a road. A driver pulled over for a minor traffic violation. Nothing serious. The kind of stop that should end with a warning and take less than 10 minutes. The officer approaches the window. The driver is calm, hands visible, cooperative from the first moment. He discloses clearly and without hesitation that there is a legally owned firearm in the vehicle. No erratic behavior. No suspicious movements. No indication of criminal activity of any kind. By every objective measure, a model interaction between a responsible gun owner and a law enforcement officer. The officer makes a decision. He decides the gun is enough. That the presence of a firearm, regardless of its legality, regardless of the driver's perfect demeanor, regardless of the complete absence of any other red flag, justifies a full vehicle search. The driver objects calmly. Clearly states he does not consent. The search happens anyway. And here is the part that should genuinely disturb you. The lower court sided with the officer. They ruled that the presence of a firearm alone was sufficient legal justification for the search. Being a gun owner made a person suspicious enough to forfeit their privacy. One constitutional right used as justification to override another. Then it reached the Supreme Court of the United States. 9 justices, every ideological corner of that bench, from the most conservative to the most progressive. They looked at this situation together and arrived at the exact same conclusion. 9-0. No dissents, no partial concurrences, no splits. Unanimous. Here is the core holding. Every single word matters. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. In plain language, legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat either of those things as if they are. The court delivered a direct and unmistakable message to every law enforcement agency in America. You cannot use a citizen's exercise of one constitutional right as justification to strip them of another. The Second Amendment and the Fourth Amendment exist together. They stand together. A law-abiding gun owner is entitled to both at the same time without condition, without being forced to choose. Armed does not mean criminal. 9-0. When 9 Supreme Court justices agree unanimously on anything involving firearms and police authority, Uwanger and Bakristar and Sir and Dakri and Saksir, you pay close attention. That level of agreement does not happen by accident. It means the constitutional line being drawn is not subtle, not ambiguous, and not open to reinterpretation by lower courts. 9 very different legal minds arrived at exactly the same place. Here is my question for you. Drop it in the comments right now. Which Supreme Court ruling do you consider the most important Second Amendment victory of your lifetime? Heller, McDonald, Bruin, or this one? Tell me and tell me why. I want to see what this community values most. Now, here is where most people watching this video make the mistake that turns a landmark ruling into a dangerous, false sense of security. You are thinking this ruling is a force field, that the next time an officer approaches your window, you have a 9-0 Supreme Court decision protecting you and the conversation ends there. It does not end there. There are 3 specific trapdoors built into this ruling. Know them cold before you ever need them. Trap door 1. Your legal status must be completely clean. This ruling protects people who legally possess a firearm. Full stop. If you are legally barred from possession for any reason, prior felony, domestic violence restraining order, any disqualifying factor, this ruling provides 0 protection. The gun is not a neutral detail. It is evidence of a crime. Furthermore, if an officer has any reasonable articulable suspicion that the firearm is not legally possessed, the analysis changes immediately. The suspicion of unlawful possession becomes the probable cause. This shield works only when your legal status is completely and unambiguously clean. Trap door 2. Your state's storage laws can destroy this protection. Many states have specific laws governing exactly how a firearm must be stored inside a vehicle. Unloaded. Locked container. Specific area of the vehicle. If an officer observes a firearm stored in direct violation of your state's storage statute, he is not searching based on the presence of a gun. He is searching based on a specific observable violation of a specific law. The gun is legal. The manner of storing it is not. And that distinction, while it sounds technical, is the difference between this ruling protecting you and this ruling being completely irrelevant to your situation. Know your state's vehicle storage requirements before you put the car in drive. This is not optional. This is basic preparation. Trapdoor 3, consent destroys everything. This is the most dangerous trapdoor of all. When the officer does not have enough to legally justify a search, he will ask for your permission. He will say something exactly like this. Since you have a firearm in the vehicle for everyone's safety, do you mind if I just take a quick look through the car? He sounds professional. He sounds reasonable. Every instinct you have as a cooperative, law-abiding person says yes. Do not say yes. The moment you consent to a search, this 9-0 Supreme Court ruling becomes completely irrelevant. You have handed the officer a blank check, glove box, trunk, center console, personal bags, all of it. Consent overrides the court. That waiver cannot be undone in a courtroom. Not even with this ruling behind you. Your response is 4 words. Calm, brief, firm, I do not consent. Then stop talking. Which politician in your state do you think has done the most damage to gun owner rights during traffic stops and police encounters? Drop their name in the comments. I want to see who this community holds accountable. Knowing the ruling is only half of what protects you. Knowing exactly how to behave in the moment is the other half. Here is your complete step-by-step protocol. Step 1, pull over immediately and correctly. Signal, slow down. Move to the right shoulder without hesitation. A delayed or uncertain pullover creates tension before the interaction even begins. Give the officer 0 reason to question your intent from the first second. Step 2, control every variable. Turn off the engine. Roll down your driver's window fully. Roll down tinted rear windows too. This removes visual uncertainty that makes officers tense before they reach your door. At night, turn on your interior dome light. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for anything. Do not move until the officer is at your window. Step 3, speak before you reach. When the officer asks for your license and registration, do not immediately reach for anything. If your firearm is anywhere near your document storage area, an unannounced movement toward that location is exactly how calm interactions become dangerous ones. Speak first. Tell the officer you have a legally carried firearm and ask how he would like you to proceed. This demonstrates cooperation, eliminates surprise, and places the next decision in his hands. Most officers respond to this immediately and positively. Step 4, know your state's duty to inform. Some states legally require immediate disclosure that you are carrying. Others have no such requirement. This varies significantly and it matters enormously. Know your specific state's law before you ever need it. If your state mandates disclosure, comply immediately and without elaboration. If it does not require disclosure and the firearm is not visible, you have no legal obligation to volunteer that information unless directly asked. But if you are asked directly, never lie to a law enforcement officer. One lie transforms a routine stop into a criminal situation instantly. Step 5, refuse consent calmly and firmly. When the officer asks to search your vehicle, and he may ask, in sathur ats as, this is the moment your rights either protect you or fail you. Do not argue. Do not lecture. Do not reference this ruling. Simply say, I do not consent to a search. If he responds with, if you have nothing to hide, why not just let me look? Recognize that for exactly what it is. Psychological pressure designed to make refusal feel like guilt. Respond calmly once, then stop talking entirely. Step 6, use silence deliberately. Silence is a legal tool, one of the most powerful available to you. It is a protected exercise of your Fifth Amendment rights. Do not fill quiet moments with nervous explanation. Do not voluntarily answer questions about your destination or what else is in the car. Most people talk their way into a search. Every sentence you volunteer hands the officer another building block toward probable cause. Silence removes every one of those blocks from the table. Step 7, if the search happens anyway, do not resist. If the officer proceeds to search your vehicle after you clearly refused consent, do not interfere physically under any circumstances. State clearly and loudly enough for his body camera. I dari ker is dari a docs I do not consent to this search. Then stop. Do not repeat it. Do not escalate. Your composure in that moment is not weakness. It is the foundation of your entire legal case. Every piece of evidence discovered in a search that should not have occurred becomes potentially suppressible in court. Step 8, document everything immediately. The moment the stop ends, pull over somewhere safe and write everything down while it is accurate. Exact time and location. Officer's name and badge number. Precise words exchanged. Whether you consented or refused. What justification was offered. What was or was not found. Human memory degrades fast. Specific contemporaneous documentation is what attorneys use to build winning cases. Step back and look at what this ruling means in historical context, because the significance goes far beyond one traffic stop on one road. For years, the legal framework developing in lower courts was quietly building toward a reality where gun owners effectively had to choose between their Second Amendment rights and their Fourth Amendment rights, where the simple act of legally carrying a firearm made you automatically more suspect, more searchable, less protected than a person who chose not to exercise their constitutional rights. That framework, if they ir aspar ir eyes, if left unchecked, would have created a two-tier system of constitutional rights in America. Gun owners who sacrifice privacy to exercise their Second Amendment rights, and non-gun owners who retain full Fourth Amendment protection. Two classes of citizens, two levels of constitutional protection, based entirely on whether you choose to exercise a right the Constitution explicitly guarantees. The Supreme Court said 9-0. That is not what the Constitution means. That is not what America is. And that answer, coming unanimously from 9 justices representing every ideological perspective on that bench, is about as settled as constitutional law gets. This ruling also has broader implications for how law enforcement across America conducts traffic stops. Police departments nationwide are now going to have to retrain their officers. The use of a legal firearm as the primary justification for a search is now explicitly off the table at the highest legal level. That is a meaningful shift in police procedure, and it protects every law-abiding gun owner every time they get behind the wheel. Gun Guide Pro exists to make sure you understand these developments in real time, not weeks later when you read about them in a comment section. Not after you have already needed them. Right now, before your next drive. Before your next traffic stop. That is what this channel is built for. And your support, your subscriptions, your likes, your comments is what makes it possible for us to keep delivering this coverage to you. We are a new channel. We are building something real, and every single person who subscribes is investing in a resource that will be here the next time a ruling like this drops, and the time after that, and the time after that. Here is the absolute bottom line. The Supreme Court ruled 9-0 that your legal firearm cannot be used as the sole justification to search your vehicle. Armed does not mean criminal. Your Second Amendment right and your Fourth Amendment right stand together at the same time without condition, without being forced to choose between them. That is now settled constitutional law at the highest level. But this ruling only protects you under 3 specific conditions. Your legal status must be completely clean. Your firearm must be stored in compliance with your state's vehicle storage laws. And you must never hand away your protection by consenting to a search you were never legally required to allow. Know the ruling. Know the 3 trapdoors. Know your 8-step protocol, because your rights are only as strong as your understanding of them before you need them. Here is what you do right now. First, subscribe to Gun Guide Pro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation to keep producing this level of content for you. The next ruling affecting your rights could drop tomorrow. Be here when it does. Second, smash that like button and share this video with every gun owner you know who keeps a firearm in their vehicle. Most of them have never heard of this ruling. Your share could protect someone you care about. Third, answer all 3 of my questions in the comments right now. What state are you watching from? Which politician in your state has done the most damage to gun owner rights? And which Supreme Court ruling do you consider the most important Second Amendment victory of your lifetime? I personally read and respond to every single comment on this channel. Gun Guide Pro is just getting started. The cases coming over the next 12 months are going to be historic. Be here for every single one of them. Stay informed, stay armed, stay free. I'm Michael from Gun Guide Pro. See you in the next one.